Gang. 1, 2. Okay. Die. 100. 90.
Good morning everyone. Can we please settle down? We are about to start. Ke kopa re tse ditulo tsa rona re dule mofatshe. Le kope le ba leng ko ntle. Ba kene ka hare re kgone ho thoma ka mosebetsi wa rona. Wa bolela mo ke chairperson re filwe ke kana. Chairperson ya Portfolio Committee ya Social Development in the Gauteng Provincial Legislature. Ke rata go le dumedisa maloko kaofela leng ka mo. And ke dumedise le those that are joining us on the social media platforms. But before I do that, let me do first things first. Ho ya ka molao wa legislature, whenever we have a meeting outside the precinct of the legislature, we have to declare that precinct as a formal legislature. So I'm going to start with the proceedings. Ke thoma pele ka ho declare this venue as the precinct of the legislature. I, Refilwe Kekana, Chairperson of the Portfolio Committee on Social Development, hereby declares Chief Mohale Hall as the precinct of the Gauteng Provincial Legislature in terms of Rule 56 of the Standing Rules of the Gauteng Legislature, read together with Section 1 and 2 and Section 28 of the Powers, Privileges and Immunities of Parliament and Provincial Legislature Act number 4 of 2004. Thank you very much. Nesetse ke le dumedisa, ke dumedise le boetapele bo ke na le bona in front of me, members of the Portfolio Committee who are here, as well as officials from the National Department of Social Development, as well as officials from the National Council of Provinces, officials from the legislature, all the media personnel, and those that are responsible for interpretation at the end. Before we start, maybe let me explain. We will be using various languages as we speak to yourselves, and you are also allowed to engage in any language of your preference. But honali the gadgets, ne? So if a presentation is made ka English, for instance, you put in these gadgets over your head, and then if you batla utlwella ka Sesotho, you will be able to press channel 4 on the gadget, and for Sizulu or Sixhosa, channel 2. For Chivenda or Chisonga, it's channel 5. For Africans, it's channel 3, and English will remain channel 1. So those of you who would require to use the gadget, you can just raise your hands, and the media people will distribute the gadgets and show you how to actually operate the gadget so that you don't miss on any information with yourselves. I hope that is clear. You can just raise your hands, keep it up until they give you the gadget. In the meantime, I will request then the Honorable Speaker from Mohale City, Honorable Tonia Honorable, what's her name? Honorable Councillor Jackie. Sorry, I've got your name here. Councillor Jackie Panel. She's sitting on my right-hand side. She's the speaker in the Mohale City Council to do an opening welcome on behalf of the committee. Over to you, Honorable Speaker.
Thank you. Good morning, ladies and gentlemen, members of the public. Hello.
Can we do this thing quietly as possible, because we are starting with our proceedings. We've already wasted enough time, so can we please start? Thank you. Let's give Councillor a hearing.
Good morning, ladies and gentlemen. I would like to take this opportunity of welcoming the Portfolio Committee of Social Development and the stakeholders and the presenters to Mogale City on behalf of the Executive Mayor, the Whip of Council, the MMCs and councillors, and the residents of Mogale City. We welcome you to Mogale City and thank you that you are including us in your public participation. I believe there are stakeholders from Sedibeng as well in our midst and further West Rand. Welcome to Mogale City and thank you very much, Madam Chair, for giving us the opportunity of hosting your public hearing. Thank you very much.
Thank you very much, Speaker panel, for welcoming us in your territory, Raleboga. We do have an agenda, guests and colleagues. In terms of our agenda for today, we are now going to deal with the apologies that we have received from other members, and thereafter we'll deal with the purpose of this meeting, followed by a presentation by the National Social Development on the Children's Amendment Bill, which will be done by Mesibongile Khoza. Thereafter, we will get into the most important session, the reason why you are all here, to deal with the clarity-seeking questions and the comments based on the department's presentation. And thereafter, we will also request those that have got written submissions to bring them forward to the table, because I'm sure not all of you will have an opportunity to speak, but some of you I know have got written comments. Halidi Tswere, just bring them forward so that your comments and your inputs can be taken into consideration as well. Sipo, can you just tell us the apologies?
Good morning, colleagues, Chair, honorable members, stakeholders. Chair, we've received two apologies. One is from Honorable Dolile Dwaba, who's out of the country on legislature business, and the other apologies from the permanent delegate, Honorable Mulelo Baha, who is engaged in another meeting that is clashing with this one. Other members, Member Nsaka is going to arrive late, and then there are no other apologies that we have received. Member Paternost is writing exams. Those are the only apologies, Chair, that we have received. Thanks very much.
Okay, thank you very much for the apologies, Sipo. Yes, I have actually deliberately skipped item where the permanent delegate is supposed to make an input, because I'm aware that he's not with us today, and I think all the apologies have been accepted. I hope I'm correct, honorable members. Do we accept the apologies?
Yeah, thank you, Chairperson. My name is Member Togozile Makakula. I move for the adoption of the apologies.
Okay, thank you very much, Honorable Member Magagula. Without any further waste of time, we'll get on to the next item, which is the purpose of the meeting. As you all know, the Children's Amendment Bill, Bill 18B of 2020, has been referred to the Portfolio Committee on Social Development for formal consideration in terms of Rule 245 subsection 1, read with 246 subsection 1, 247 and 248 of the Gauteng Legislature Standing Rules. The Committee on Social Development aims to conduct public hearings to solicit inputs from you, yourselves, members of the community, members of the public, on the bill, as is the case today. And in light of the above, myself and members of the portfolio committee and the department has invited all of you, as well as those on social media platforms, to take part in this public hearing on the Children's Amendment Bill, which is scheduled for today, and there's another one scheduled for Wednesday, which will take place in the Johannesburg City Hall. And I'm sure all of you have received a copy of the bill, which is circulated in the packages that you have received. And I think the purpose is basically to give you, our stakeholders from Sidibeng, as well as the ones from West Rand, an opportunity to interact with this bill. You will all remember that this bill was introduced to the National Assembly in August of 2020 in order to make certain amendments to the Children's Act number 38 of 2005. The Portfolio Committee on Social Development in Parliament has also conducted hearings in the different provinces on this bill. And if you remember, they were here in Gauteng from the 25th to the 29th of November 2021. And I'm sure some of you might have attended those hearings, and you would have had an opportunity to also interact with the Portfolio Committee from National. Ours as a Portfolio Committee in the Gauteng Provincial Legislature is to listen to your views and to make sure that whatever your concerns and issues that you are going to raise as relates to the bill are taken into consideration. The plight of children and issues related to foster care has been one of our priorities as a Portfolio Committee. And as such, we did conduct a webinar on the 10th of June 2021, which was focused on the review and assessment of the processes of foster care applications and placements here in Gauteng. We are quite happy as a Portfolio Committee that the process is where it is today, where we find ourselves having an opportunity to engage with yourselves. And we hope that we will be able to impact and change the lives of the vulnerable children who are in foster care. Without any further waste of time, I will allow the National Department to provide us with the necessary clarity to all the areas that needs clarification as contained in the bill. So at this stage, I will request Ms. Bongile Khoza to take us through the presentation. Over to you, ma'am. Thank you very much.
Okay. Thank you, Chairperson. I would take it that, Mr. Ngomane, you've already projected the presentation? Thank you. All right. Good morning, the community of Kagiso. Lekae bagaetso? Ke tshepa gore we'll be able to get an understanding of what are the amendments that are made to this bill, so that you can be able to obtain the inputs tsa lona to ensure gore re bana le a children's bill etlo thusa gore re etse the child protection system, of which foster care is part of that system, to be more efficient. Thanks. Now, the purpose of this presentation is for the Gauteng Provincial Legislature to present the contents of the Children's Bill, so that we're able to source your responses to respond to the comprehensive legal solution in relation to the foster care challenges as ordered by the North Gauteng High Court order. And if I may just give you a brief background so that you understand how will these comprehensive legal clauses will contribute to the foster care system. the foster care system is part of a child protection system. And the child protection system consists of various programs that would be aimed to respond to the challenges that children are faced with. And part of those components, they include child abuse, neglect, and exploitation. It includes foster care. It includes child and youth care centers. So all of that comprises a child protection system. So you'll notice as I go through with the presentation, when I make reference to the foster care system, I will do that in relation to the child protection system so that you get a fuller understanding of why some of the clauses that may not talk directly to foster care, but they are included in this bill. So it's with that understanding in mind. So the North Gauteng High Court order in 2017, it made 2 declarations. And these declarations, they can also be understood in line with what I've just explained, that foster care forms part of the bigger child protection system. So the order indicated that the delay by the first respondent, of which is the minister, resulted in preparing and introducing the bill before the parliament to amend the legislation to produce a comprehensive legal solution in respect of foster care system as unconstitutional, unlawful, and invalid. The second declaration stated that the delay in putting in place the necessary mechanisms, structures, and resources to ensure the foster care system operates in a sustainable and effective manner is unconstitutional, unlawful, and invalid. And these 2 declarations were suspended before the North Gauteng, which meant that if it's suspended, then those declarations would not be applicable for the duration of the North Gauteng High Court order. And noting that this initial order was issued in 2017, so in 2019 and 2020, it was extended. So that means these declarations are still suspended. And based on this brief background that I've just given to you, out of the entire bill that was consulted with all the stakeholders and communities in the previous year, there are several clauses that were extracted so that the parliament can be able to process the bill to ensure that there is a mechanism that is put in place in terms of the comprehensive legal solution so that we can be able to manage the foster care services before the North Gauteng High Court order ends. So 12 of these clauses were extracted, and you will note in the presentation that some of them would not be directly about foster care, but they link with foster care directly. And that's why we will be having 12 of these clauses. And these clauses then, they form a legal framework of which the North Gauteng High Court required that there should be that comprehensive legal solution, which would be a legal framework in that regard. And so that you can be able to manage the foster care services and more so manage the foster care orders to ensure that they do not lapse. And in terms of the mechanisms that are being put in place in terms of this bill, they would begin with the definitions, and part of the definitions would enable the implementation of some of the clauses that are contained in this bill. And it also puts the structures and mechanisms that are required to render an effective foster care system, which also incorporates of the foster care services. And more so, it seeks to diversify the legal mechanisms to ensure that we provide best possible care for children who are in need and in need of care and protection in terms of the Children's Act. And based on the clauses that are included in this bill, part of the components would require that we have an element that will enable us to identify children that are at risk, identify those children that would then require an intensive intervention so that these children are able to receive the quality care and protection of these children through the children's court processes, which would then consist a more effective child protection system and not just the foster care system. And most importantly, provide a mechanism to manage the foster care orders that would require to be extended over a period of time until such time that such a child would be discharged from the foster care system, or the child no longer require such a service because he or she has turned 18 or is no longer furthering his or her education when he turns 18 up to the age of 21 years. And most importantly, also, it makes a provision for supervision of these foster placements. The bill also seeks to streamline the provisions of the cluster foster care provisions in the Act, because the foster care system has a component of cluster foster care services that would enhance the provision of quality foster care services through the provisions of this bill. Now, Clause 1 of the bill relates to the definitions, as I've indicated, which would then include cluster foster care. And it also has a definition of an orphan. And the definition of an orphan will be applicable in the sense because the Children's Act is a principal act on matters pertaining to children, and any other legislative framework that would be put in place would need to align to what we have in the principal act. And in this instance, then the definition of an orphan would enhance what we currently have in the act, where a household that has a single parent would then be identified as such in terms of that person passes away. And noting that the current Children's Act would make reference to both parents being deceased. So in this instance, it will be applicable even to to a single parent in case the other biological parent cannot be located or his or her whereabouts are unknown. And this definition would also assist us in terms of implementing the Social Assistance Amendment Act that was recently proclaimed in 2020, which is currently being implemented through the SASSA provisions. And the bill then makes a provision in terms of amending sections 24 and 25 through clauses 3 and 4, where the bill makes a provision that would ensure that there are mechanisms that are being put in place to ensure that the children who may be orphaned or abandoned, or any other child who's found to be in need of care and protection, would require a legal mechanism to ensure that such a decision is being made appropriately by the children's courts. And furthermore, the bill also makes a legal mechanism contributing to the comprehensive legal solution, in a sense that the child protection system would be strengthened in a manner where there would be various options that are available to respond to the differing needs that children present with. And in this instance, the bill makes provision for the caregivers who are caring for children who may not have the biological parents who may be deceased by gaining access to guardianship. Currently, guardianship is being processed through the High Court, and which is very costly. However, with the amendment of this bill, such a service will be available in the children's courts, which is not costly as it is currently. And this would be applicable in a sense that whenever a child is brought before a social worker that may be orphaned, it may not necessarily mean that such a child would be in need of care and protection and be put through a foster care system. It may require that the caregiver would need some form of legal documentation to enable that caregiver to make decisions on behalf of the child or to access certain services or benefits that would benefit the child through that legal document, which is a guardianship. And if the caregivers are able to care for that child, then it's one other option that is available that can be utilized. And in terms of clause 4 of the bill, it then puts these required mechanisms in a sense that there should be a provision that should be put in place where all the child protection services, not just foster care, they are quality assured. The reason for this is because if a child who may have been exposed to certain circumstances, or maybe a child behaves in a particular manner, and that child is not receiving the immediate prevention or even early intervention services, there's a likelihood or a possibility that such a child may through foster care or even be placed in a child and youth care center, which in terms of the social work practice would be seen as going deeper into the system, because the child protection system has several components, if I may put it that way. You have prevention services that would prevent a problem from becoming bigger and then require interventions at a level where that problem can be contained in that manner and avoid it being escalating much further than what it is. There's a second level, which is early intervention services, where a problem would have already occurred, but it can be managed at that level without letting the problem magnify even more. And if the issue has escalated even further, then we have the third stage, which is statutory services. And if an issue then requires statutory intervention, then that means the problem may have escalated even much further, which then requires the intervention of the children's courts. So part of an explanation that I provided earlier on of the foster care system being part of the child protection system, that's what I was referring to. So that if we have that quality child protection system, then there's a likelihood that lesser children may require to be placed through foster care or even child and youth care centers. And such children may be able to continue with their lives that are being enhanced within the situation that they may be living within, without being removed or being placed under such stringent care, such as foster care or even child and youth care centers. So that's why we need such a child protection system being quality assured to ensure that all the time such services are being rendered effectively. And clause 5 of the bill it further addresses these systemic issues of which Declaration 1 of the North Gauteng High Court order, Declaration 2 of the North Gauteng High Court order referred to. Because yes, you may have this system and have this quality assurance in place. However, if you do not have the enablers or the aspects that would enable the social workers to apply the provisions of the Children's Act effectively, then the Children's Act or any other legislation would not be implemented in a satisfactory manner, because those enablers are not there. So clause 5 seeks to do that by requiring that there should be sufficient social workers to provide child protection system that would include foster care services, so that they provide the services that are made reference to earlier on. Please keep that in mind when I talk about the child protection system, the explanation that I provided earlier on, that it has to be this bigger system that we look into, on which foster care is being part of. So clause 5 seeks to ensure that there would be enough sufficient social workers to provide child protection services as well as foster care services. And also, those social workers would have the required resources for them to do their work, such as cars, laptops, access to data, to be able to access the network so that they're able to write reports or engage with other service professionals like the doctors, so that they're able to gain access that would enable them to render an effective service. So all those resources are required so that we have a functioning system, including social work supervisors, because the social work profession works more efficiently when there is that ongoing and consistent engagement amongst the peers in a structured manner, so that they keep on improving on their interventions with their clients. And clause 6 of the bill then makes a provision for the establishment of these child protection units, so that we're able to have such a comprehensive service for children who are in need of care and protection. And clause 7 seeks to strengthen the provisions that should be put in place for orphaned and abandoned children who are in the care of their family members. And such placements may not necessarily require that there would be such a thorough investigation. However, part of a social work intervention involves a very thorough social work assessment. And in this regard, then social workers would be required to provide such a service, so that they are able to determine beforehand the type of a responsive intervention through such an intensive assessment, so that it guides their intervention. And in terms of clause 8 of the bill, it further makes provision for the courts to determine whether a child is in need of care and protection. And it then enables the courts to determine that if such children would need to be placed in care, one of the provisions makes reference to the people who form part of the cluster foster care system, where you have individuals who would be assigned to care for children who are placed in that cluster foster care scheme. Because foster care orders that are issued by the children's courts, they may place a child with a family in their respective homes, or place a child in a cluster foster care scheme that is registered as prescribed by the Children's Act, and also in terms of the amendments that are made in this bill, so that we're able to provide an effective service to these children. Furthermore, the clause 8 also makes provision for children that would be determined by the court to be in need of care and protection to be placed with the family members, so that they can be able to receive the type of care that would further enhance their relations as the family members, without having to remove the child and placing that child for instance, in a child and youth care center. And we then have clause 9 that makes provision for the assessment of children in terms of the prescriptions that are made by the Children's Court, in terms of the provisions that are made for in the Children's Act. And this clause would also require that a social worker would have to provide supervision services to the children as prescribed by the Act. It also makes provision for children who are below the age of 3 years, where possible, to be placed in adoption if they are orphaned and abandoned. Because at times you would have children that would go through a foster care system whilst they are still very young, whereas, and actually one would need to note this difference. Foster care is a temporal form of statutory placement, compared to adoption, where adoption is a lifetime, if I may put it that way. It's a lifetime placement being authorized by the Children's Court. And in that way, if such a child from such a young age is placed with an adoptive family, then they would have a long-lasting relationship with that family without any risk or possibility of being moved from one foster care placement to another, or even further down to the child and youth care centers. So this is one of the clauses that I made reference to earlier on, that it may not really talk about foster care, but it actually directly relates to foster care, because part of the decisions that would be made by social workers when they are conducting their assessments, it will then inform them which form of care is suitable for that child. And in this instance, then such a child can be placed through the adoption system. And noting that such adoption placements would firstly be considered to be within the country, so that such a child would continue to maintain his or her identity. And in terms of clause 10, it makes a provision for the amendment of the current section 159 of the Act, where if a child who is placed in foster care and child and youth care centers, if it happens that their order lapses, which is the current problem that we have experienced with the North Gauteng High Court order, so this clause enables the children's courts to extend those orders. So which means, even if an order would lapse, then the court has the prerogative to extend the order, so that the foster care order or a child and youth care center order does not lapse for a period of 6 months. And with that interim order being issued, a social worker will be required to appear before the court with a comprehensive report on good cause shown that social worker has conducted an investigation and such a child indeed still requires to be placed in foster care and or even a CYCC, so that the court can then review its initial decision in terms of the amendment of section 159 or clause 10, and then extend that order for a period that is longer than 6 months. It may be for a period of 2 years, or it may be until the child turns 18 in terms of the current provision of section 186. And this clause further makes an insertion that would require that children who are already in the foster care system, they must not be discharged, or their placements must not be terminated based on the amendment that we've had in terms of section 150. So that means their placements will continue to be in place until that child turns 18 or he or she turns 21, if the child is furthering his or her education. And probably if one can further clarify the amendment of clause 6, so that you clearly understand it in terms of clause 10, you'd note that section or clause 60 would not include a child who is in need of care and protection as a child who's orphaned and abandoned in the care of a family member. Okay? And such a child will then be catered for in the amendment of clause 11, and I will explain it to you in a short while on how these two interlink. And then we have an amendment for clause, in terms of clause 11, which makes a provision for the minister to make regulations for a child who's orphaned or abandoned in the care of a family member, to determine whether that child is at risk. So you see now the correlation between, or how these two link. The amendment of section 150 does not determine, identify this child as in need of care and protection. However, it still recognizes, or the bill still recognizes, that such children that may be in the care of family members, we would not automatically exclude such children through this bill, because there's a likelihood that such a child in the care of a family member may be exposed to some risk. So where it is required, then that matter would need to be reported to the social worker, so that the social service professional would conduct a risk assessment. And if it's determined that such a child is at risk, then the matter would further be investigated by the social worker to determine whether a child is in need of care and protection or not. And if that determination is being made, then the matter would have to be taken to court through a social worker's report, and the presiding officer or a magistrate then makes a decision that that child is in need of care and protection. So this means that if orphaned and abandoned children that may be in the care of family members, they would be found to be at risk, even though section 150 does not identify them as those that are in need of care and protection, based on the decision that is being made by the court, then the child can be found to be in need of care and protection, and that child may be placed in foster care or any other form of alternative care. And then we have an amendment for clause 12, which makes provision for children who are placed in foster care through the cluster foster care schemes, by protecting them in such a way that such organizations that render or that would like to provide cluster foster care services or that are already registered to render cluster foster care services, they would not only be the non-government, non-profit organization, however, they need to be designated as child protection services in terms of Section 105 of the Act, because cluster foster care is a part of a foster care service that should be designated to the respective organization. And this clause further enables the Provincial Department of Social Development to establish and run cluster foster care schemes. So these schemes would not only be, be implemented by the NGOs, the government can also render cluster foster care services based on these amendments. And Clause 12 further makes a provision that such designated organizations or the department that would render a scheme, they would need to render such a scheme as prescribed through the regulations that will accompany this bill. And then the amendment for Clause 13, it makes provision for not more than 6 children that may be placed with a foster parent or 2 foster parents in a household. So that household cannot have more than 6 children. Just to make an example, you may have one parent being allocated 4 children, and the other parent may be allocated 6 children. So that will not be that will be unlawful. So that household, it should contain 6 children, but not less than, but not more than that. Not unless if the children that are to be placed, they are siblings, which is the current provision in the Act. So children who are coming from the same family should not be separated. Okay. And we have an amendment for Clause 14, which amends Section 186. It makes provision for the children's courts, based on its orders, strengthen the supervision of the foster placements. Because the current Children's Act makes provision for the presiding officer to issue a Section 186 order where a child may be in foster care for more than 2 years and probably even until the child turns 18. And currently it makes provision for the courts not to make or not to require further supervision. But because of what we explained earlier on in terms of Clause 4, in terms of strengthening quality assurance would link with the provision of supervision services of these foster placements. And through this amendment, then the courts can issue Section 186 orders requiring social workers and social service professionals to monitor and supervise these placements. And when one makes reference to social service practitioners, it may include your social auxiliary workers, it may be your child and youth care workers, or your community workers. So all these officials, they would feed in their reports to the social worker who is managing the case, and the social worker would furthermore render supervision services so that that placement that child in that placement receives quality care as required by the Children's Act. And but just note that this clause further makes a provision that children who are placed in cluster foster care schemes cannot have Section 186 orders. Because remember, earlier on I said foster care is not a a long-term placement. It's ideally a short-term placement, and a cluster foster care scheme that is managed by an organization where there's a likelihood that the caregivers in that scheme, they may rotate. So such a child may not be able to establish long-term relationships. However, with a foster care placement that is within a household, such long-term relationships may be established. Hence, Section 186 made provision for longer-term placements. And then the clause 15 that amends Section 312, it makes provision for the MEC for the social development to put in place the required strategic plans, enter into agreement with the designated child protection organizations or the appropriate persons for the provision of any service that is required in relation to children on a basis that it's within that particular province. And the last part of clause 15, it requires the minister or the MEC for social development to delegate such an organization with powers and duties that may be in terms of this act. And clause 16, it's mainly a short-term title for this act, which would need to be proclaimed by the president in the required gazette. And that that brings to an end my presentation on the overview in terms of the clauses that are contained in this bill. And I'm handing over to you, Chairperson. Thank you.
Okay. Thank you very much, Ausibongile, for the comprehensive presentation. Ke tshepa hore ne le tlhoile tsebe kaofela ha lona re utlwile the sections of the bill that have been amended. She went on through all the clauses that are relevant, and I'm sure you have noted your inputs and your comments, because ka se sebaka I'm going to afford you an opportunity ya hore le raise di comments tsa lona le botse le clarity seeking questions mo elong hore le fahlehile mo teng ha le utlwisise. As you all know, rena erele portfolio committee, our responsibility is threefold as the portfolio committee in the legislature. Our duty is to do oversight over the Department of Social Development in the Gauteng province, as well as lawmaking and public participation, which is what we are doing today. We are here to facilitate the public participation process, enable you and give you, the public, a voice, to have a voice in the matters that concerns your lives and the lives of our children. So I'm going to start on this side, on my left-hand side. What I'm going to do is, if I point you, you just come to the front, le form a line of the speakers, because I'm not going to go back. I'm going to appoint Matsoho, le tlamopele, le form a queue, and then you'll have an opportunity to speak. And those of you that have got written comments or submissions, like I said, even after the processes, or even during the process, you can just bring your submissions, on the table at the corner. You just drop them off, you sit down. Side A will come over to this side. And then the department will provide all the responses. Or perhaps we will, after this side, clarity, so that even if you have a question this side, at least it will have been covered, because the questions may be different, but the responses may be the same. But we will see as we go along. So let's start with the process. I'm going to take hands on the side, on my left-hand side. Ke kopa le emise matsoho, ha ko nouta, you come to the fore. Okay? Number 1, you can come. My brother, come. Number 2, akai matsoho. I saw 2 hands this side. Okay, let them come. Okay, let me move this side. Kitse matsoho amang so that refelel. Number 1, Papa, you can come. Over number 3, yeah, join the queue. Number 4, come, join the queue. Number 5, come, join the queue. Those are the 5 hands that I've got. Tse batlang clarity, or they want to make comments or inputs. Thank you very much, in that order.
Oh, thanks. Siyabonga chairperson presentation. So lona ubonga nikamthembu from Esibukeni. No, sizwile presentation. So mina I was off the view ukuthi High Court it declared ukuthi this foster care because there a lot of confusion. Even now, the presenter, Malokai presenter, I thought mhlambe izokhona nokuthi address the issue yokuthi if foster care iphelelaphi ngiyawuzwa ukuthi 18 years kunalapho ilapsa khona of 21 if ever umntwana osaye esikoleni, but it doesn't address the issue yokuthi the very same children or a child is still orphan even after those years. So that issue i-addressa kanjani because umntwana noma ngaba sekandlulile kulesigaba lesi 21 or 18 still on orphaned. So there is any substantial evidence ukuthi angeka survive beyond that na usadinga unqid akuna any intervention that can be created for that ukuthi mhlambe makasuka lapho awela to another stage whereby uzokhona ukusizakala going forward. Another issue that I wanted to raise maybe confusion that I've maybe also caregiver and the guardian. So in that act, how their role, it seems like the role is different, but not clear. Ukuthi kahle kathi mawukhuluma nge-caregiver, ukhuluma ngani, mawukhuluma nge-guardian, ukhuluma ngani. So they are also stipulated. Why don't you use one term that's not going to confuse abantu in terms of applying and also participating on this? Yeah, I think those are the 2 questions that I wanted, because if ever want to address the issue of child protection system, it's not clear ukuthi ni addressa kanjani, even though the NGOs on the ground, we are so much interested to assist. And also the last one, Chairperson, the last one, issue the child-helded families. Where did they fall within this, the very same child protection system? Ama child-helded families, child-helded families. Yeah, thanks.
Thanks, Chair. Igama lami nguMaster Push Xolelizwane. Ngihlala khona apha ekuhlaleni eKagiso. Chairman, at least namhlanje your voice is not screeching. Thanks to uthatha i-COVID, you know. But Chair, my point is here, man. You see, this thing, if you're speaking more about it, like the court. So then kabanga kutuena no mama kakula nizaza na lawyer here, including a magistrate. Nizoba teacher about this act. Because I want to know singaya a court. Especially Tina Singakov ama families. They will say, no, Master Push ngakungene, sifuna i-family. And then senza kanjani la ku child court. That's the problem esizoba nayo. And then Chairperson, Sisirifino, next year, ndicela ukuthi budget ye-department ingasakhatiwana. Because Tina singabazali sinama problem. abantwana bethu abatholi uniform. And mathi ku department bakutshela ukuthi ilontizana ikhathiwe. Mathi and the other thing mama Kakula into engizoyicela ngicela ukuthi nibe nama social worker. Ngivile umama ngapha ekhuluma ukuthi ama social worker this and that. But manje ezikolweni especially ku primary la uthola khona ama orphan and so on. You don't get ama social worker. That's the problem esinayo. And then enye into engifuna ukuyicela mama asina problem only nento is but also our children abana ma uniform. No ndicina ndifaka ku WhatsApp ka Comrade Sipho. I forgot his name yakhe. Comrade Sipho, can you help us in our shoes and so on? Ngicela ukuthi nayo that thing ibe khona. The last point ngoba nginazo zi20 njengesanko but I will make few of them. Sine center la ekhulukazi bayibiza ibhusasa. Can't we use that center for abantwana bethu ukuthi bayohlala khona, especially ababa abandiwe and so on, so that sizokwenza that Comrade Sipho le upremier beyikhuluma ukuthi ufuna ubona iGauteng kungekho umuntu elala estradini. And thina la eMkhali sine problem yama labantu ababhekayo ama child beggars, asazi ukuthi bathola ama grandmother why bakuba ngama child beggars. And then another thing when sisirifilwe no, I will come back for second round. Thank you.
Dumelang kaofela. Ke tswa ke le Ward 17, leng Zerebecom, Waterpan and Waterworks. Se ke tlo se botsang pele ke question ya social development hore social development ina le budget for foreigners na. Ha ke botsa so ke botsa ka mabaka ana. Jwale ka ne le tseba hona eno re na le bothata ba dizamazama le di mine tse kwalwang hona eno. And those miners ba bangata ba tswa kontle ba siya bana ba bona mo. So bana bao ke bana ba kontle ke bana ba mixed e leng bana ba di South Africans le di foreigners. So what is the social development e etsang hore bana bao ba tlhokomelwe o ba busetswe to their countries? Kane la tseba hore jwala ka re le batho ba batho moetlo o important. Moetlo important. So a ke tsebe ne ke suggesta hore a ke tsebe ho ka etsahala hore for go be le registering ya di foreigners le di gore motho ha batla o data motho wa kontle tshwantse a be registered in a way ya gore re tsebe go phepa ntho ya gore bana ba ska tseba mo ba tswang teng, gore ha motho a tswa kontle if o batla o data motho wa South African a registeriwe pele a registere le social development kapa home affairs gore re phepe taba ya bana ba salang ba bangata ba re sa tsebeng gore ba tswa kae. Thank you.
Thank you so much, Chair. Me Refilo Kekan. Meshak Mtibet is my name from City Bay. Three things very quickly. That is in relation to Children Amendment Act. I just need us to deal with the recourse, because the North High Court seated on this particular matter in 2017. This is 2022. And in the process, according to the definition of a child, in the process there were children who were under the age of 18. And along the line, they are no longer going to be called children. What will be the recourse for that? Number one. Two, all our magistrate court in Gauteng, because at times we find it extremely difficult to pursue these cases through social workers in a court. they will say that they don't have this amendment. And subsequently, at the end of the day, children are the ones that is going to suffer again. The shortage of social workers or auxiliary social workers in the country also put a lot of strains. At the end of the day, once again, children are the ones that are going to suffer. There are cases, the government is also depending on non-governmental organizations to put these particular cases in a court of law. But at times, and I mean at times, these cases take too long to be processed and to be heard in a court of law. Can't we have another mechanism of speeding up these particular cases so that at least at the end of the day, children are being given justice which they deserve? Thank you so much.
Good morning. Me, I'm a fellow David. I'm coming from Bopelo. At odd 6. One thing which I want to know, what government is making the things to us? Because now the people that are standing by nothing going forward. See? And one thing, I want to ask one thing, why the government don't build the new schools or something which is going to help us all to live in? And again, one thing which I want to ask again, why the government they don't make maybe the good clinics? Because if you go into the clinic, you find the queue there, the long queue. And the nurse, they will tell you, why are you coming at late now? You don't keep the time to come to the clinic. I'm ending there.
Ke tshepa re a feletse matsoho. Am I correct? Okay. RFA department an opportunity to respond, and maybe just to declare that uteng motho wa legal ne. I'm sure o tla kena le ena responde from her legal aspect, legal side of things in relation to the question that you posed. So thank you very much for all the questions, the inputs and the comments. I think those are very positive comments from all of you. And I still invite the written submissions. Lau ka ngwala on a piece of paper, ngwala and bring it here. We want all your views. I am now going to hand over to the department and whoever else is in a position to respond, either from the regional office, our social development, Bateng Lebona, the team from the regional office, national and legal, if there's a need to intervene, the responses, Ditla Kwahala. Over to you, Ausbongile.
Thank you, Chairperson. Okay. I will make an input in the response in some of the questions that are asked, particularly in relation to the provisions that are provided for in the Act. The Children's Act, in relation to the question that was asked about street children and the services that they would receive children in childhood households. The Children's Act it's a provision for banabao. Let's say ngwana or ling a street child. Section 150 of the Children's Act, pardon me. Section 150, yeah, Children's Act, it's a provision for ngwana who may be in a difficult situation to be brought before the court. Okay, but the services to such children may not only be limited to services that may be rendered through the children's courts. So based on the programs that are available within the department, there are other services that may be rendered within the province, and I think a province or the regional colleagues will also add in this regard. An example with regard to bana who are in child-aided households. Children's Act makes a provision for hangwana ali in a child-aided household. There can be an adult supervisor that oka appointiwa ki HOD ya social development. But based on the assessment ya social worker, then that will determine hore ki service effing etwanelehing for efanelegile for lo mntana loyo based on that family abanabao who do not have a parent. And if one other option that may be available based on the social worker's investigation, that those children may even be placed in foster care. So that's another possibility. So it's not that the provisions of the Linko Act they are limited in a way. Differ the options but based on that social worker's assessment, then a service available would be provided for Go Children's Act. And there's a possibility, I may have not heard the question that was asked by Uputi regarding bana who are 18 years. But I'm taking it, you probably wanted to know, who will be turning 18 soon, most probably because habakona babeko foster care. I'm not sure, maybe if I can get a clarification with regard to that question so that I give an answer a straight man. Thanks.
Yeah, I think you also missed, there was a question around the difference between caregiver and guardian. If you could just perhaps zoom into that one as well.
Let me rather start with that one so that we get a clarification with the question around the 18-year-olds. Children's Act iberekisa the terms tse mmalwa gore go be na le ukuthi kwazeke ukuhlukanisa amongst abantu abanekela abantwana for izathu ezihlukile. In this instance, the Children's Act does in a definition ya caregiver, but aya addwa on this bill, which is an abridged bill. It will address the comprehensive issues that foster care. But bill ehulu that was consulted a few months ago in a definition ya caregiver. So it will make a distinction for a caregiver. It's a person or dulang libana, maybe in a class of foster care scheme or in a child and youth care center. So it does make that provision. And a guardian, difference ibatenga hore, according to the legal terms, a guardian would be itloba mutu or appointiwe ki court hore. Ntate Mahlangu, I'm giving you authority hore ube a guardian of this child. So guardian in a legal status a more concrete than a caregiver, because a caregiver can be maybe a auntie or dulang lingwana or tlhokofetseng kimme without having approached the social workers or even the court. So that person a ka bonwa as a caregiver. But difference ke gore caregiver would not have a court order. Etlo tjho gore that person o fiwe authority ya gore a tlhokomele ngwana. And I think
I think Mishako ona botsaka the recourse. I think the point that he was making was on the recourse on Banaba turning 18 now, who did not benefit in the system, who might have been missing the system, if I understood him correctly, but his point was mainly on the recourse.
Okay. The government ibele various or the services tse dingata gore bana ba ka di accessa based on the circumstances e bana le tsona. So a se gore di tloba limited fela ko Children's Act. Ne? Let's say ngwana nali 15 years and who apply for an investigation gore social worker determine gore ngwana may be in need of care and protection, maybe ka bewa ko foster care or child and youth care center before bill iba teng, and utlo turn 18, let's say this year or early next year. Ngwana can access a child support grant that is provided for through a Social Assistance Act because it's part of a government service. So that child would have received that service at that in that space as part of a responsive government. And based on the provisions of the Children's Act, then Children's Act identify ngwana until atena 18. So if ngwana atenile 18, that child akasibewe ko foster care or even in a child and youth care center. But understanding itloba hore ngwana o utlobe atotsi the services tse dingwe that are provided for within a government sector as a whole. Thanks, ma'am.
Okay. Any other responses from the team? Can I get any indication? If you do, yeah, you can provide the roving mic to Mama Director Mole.
Thank you, Chair. Thank you, Chair. Dumelang bagolo. Le kae? Now I'm going to respond on the issue of the school uniform to say school uniform on that we know gore ntse le bothata mo tlase ne. But the department now internal is working on the processes, Chair. So how can we go about school uniform for the new financial year? So I know to say they are preparing SCM processes whereby it might go on tender, but for now it's not finalized yet. But the department is working on the issue. Yeah, school uniform. And then concerning school social workers at schools, in Tatonang Are, you need we do have school social workers rendering services at schools because they don't fall under the Department of Education. You know, so we can't say they're school social workers, but we do have social workers rendering services at schools. Rona, looking at the number that we receive yearly, ne? The Department of Education, erifama bitso adikolo, baba bitso the hotspot schools sabona, reallocate according to say skolo se tlhoka social worker, and okgopolo gore di number tsa dikolo the social workers. Mar, it doesn't mean to say where we don't have social workers in those schools, we don't attend to the issues. Radi attend because dikolo ba refer ko di offices tsa rona. So ko re fela dikolo must strengthen their ba referring system, ko di officing. Remember to say, Rona, in our area, we do have service points in each and every area. Like Mokachis, officer is behind the police station in Mall. So officer not all over in Gauteng. I keep working Western, even in Gauteng they are there. So that school must just refer and then case it attend you. As or it will be ignored. And then budget for foreigners, ne? That we don't have budget for foreigners, but a child is a child. And how I know Alemomo Bunga South Africa. Harere ke ngwana wa foreigner eng. Remove attention elo hore ngwana mo lomo sanse a ikre according to matata anako eo. Mare bana go ya ka di social work processes. They are united with their families through ISS processes ko national. Whereby the investigation will indicate to say ngwana o haswa mo South Africa. That process e tla itsiwa ka di investigation e tla linka le ISS. ISS o linka le di social worker tsa mafatshe kaofela a. Gore krile information ngwana ha se wa mo maybe ke ngwana Malawi kapa ke ngwana Lesotho kapa ke ngwana ko kae santsa khutlele morago. So ya etsagala. Mar excuse me, we don't have a ring fence budget re tloring e ka di forest ha re discriminate ngwana ke ngwana. Thank you.
Dumelang bagolo. Ke tlo araba e ya ngwana o leng in foster care after 18 years. After 18 years ngwana ga le mo foster care a sentse a le ko sekolong. Di social worker go na le okay, the social worker go na le section 176. Re a extend jara le jara. And gape mo Children's Act wa khona go extend for 3 years. Gore ngwana a turn 21. And again, ga re tlogele bana ba rona fela. The social worker through their supervision services re na le exit plan. In the exit plan, before ngwana a tshwara 18 ra itse gore ngwana ona re tlo etsang ka ene or batla go ya university e feng or eng. Re ba linka gape le NSFAS. And mo social development re na le unit e leng gore bereka le ka di youth and other department le bone ba bereka ka di youth. In terms ya gore the social worker ka new act gore ba rutiwe di social worker ya ka director buile di teng mo di officing tsotlhe mo West Rand. Re na le di programs tse leng gore ke community programs mo e leng gore di social worker di a tsamaya di a ruta community ka ntho engwe le engwe le before re ba bana in any placement ra ba tlhalosetsa gore go etsagala eng. Yona eo e teng papa and re tlo nne re tswella re etsa and the social worker di around mo West Rand. And gape ka ISS go tlaleletsa se RD a se buile gore bana ba ngwana wa e foreigner ga re mo greile ga re mo tlogele fela before we can link with the ISS. We are through the process because the child is a child and we'll place the child in more temporary safe care until such time really clear gore ngwana o ka nnete from maybe the other country social worker ba responder yes we know this person and go ba le di arrangement tsa gore ngwana ona a tsamaye ha tsamaye a le one but o tsamaya like ramo protector so that re ensure gore ngwana o tsene safe kwa yang teng. Thank you.
Bafeletse? Okay. Ntate Mishaka o butsitse hape ka taba ya backlog ya di cases ko court. Re tlo kopa whoever are responding I cover le yona hore how does this amendment assist in resolving the issue ya di backlog, ne? Do you want to respond? Thank you.
Thank you very much. Lebitso la ka ke nna Mosima wa Rakekana. I'm working in the legal department within the legislature. I just wanted to respond to two questions, and the first one was pertaining to magistrates and lawyers in the courts. I'm sure that once the bill has been enacted, the Department of Social Development will liaise with the Department of Justice so as to ensure that the magistrates and the registrars and the lawyers that are working within the courts with regards to guardianship, who will be working with guardianship matters, are suitably trained so that they deal with matters of this nature. You would have noted in the presentation that it was mentioned that previously the High Court High Court ke yona ne ena le maloko a deal le di cases tja guardianship. So now there's been an extension. So the Children's Court and the Regional Court are now going to be able to entertain matters of that nature. So it will address a lot of the backlog that was there, because I said High Court dealing with these issues only. And also my presentation I mentioned a little about the cost implications of approaching the High Court. So now at least for Regional Court you don't necessarily need a lawyer. Even you yourself can go there and represent yourself to make an application for guardianship. Thank you very much.
Are we happy with the responses? Ke bone letsoho la ntate mo ba tlo etsa follow up, mo faetse follow up and then re tswalle ne. Oh, le wena o ba tlo etsa follow up, you asked a question before, maybe you have not been responded to. Okay, I'll give you an opportunity after him.
Ke hlaya Bophelong Ward 7. So dipotso tse botsitsweng ke bone dipotso tsa rona batho ba sports isa hlaha. So ke motho a sebetsang ka sports, ke sebetsa ka bana. So ha sebetsa ka bana o kopana le bana ba bangata ba hlang malapeng a fapaneng ka di situations tse fapaneng. So ne ke botsa from department hore rona batho ba sebetsang ka bana ma questioning e le gore ra volunteer and re so register di organizations tsa rona tse leng di team. Department re fa eng. Then ho na le bo taba ya rona le bo di trip le bo training equipment ntho tse hlokahelang di teaming tsa rona. Department ena le something e re fang tsona, although di team so ka di register ruana ke ona potso ya ka.
Okay.
No, thank you, Chairperson. Nekere me hana hlalosa issue ya difference ya a child, le question ya a foster. I don't have a problem le one because at the time issue ya high against in a court of law. Yes, that is true. Unsa thola child support grant, but I was referring specifically to the question of foster care grant. Instance of child support grant, while the issue is still in a court of law. Because you said there are various grants. Now, you did not respond adequately to a question in point ya foster care grant up until the very same child are reach 18. What will be the recourse? My question was specifically on that. Being aware, of course, there is a child support grant, but child support grant because of definition of an orphan. This is where two parents has passed away. Now, it cannot be a child support grant. It must be a foster care grant. Thank you.
Okay, the department will respond. I would do when I referral to the department. You can have a personal engagement with them. They will give you the response towards your question. Ne? Over to you, Osbongile.
Okay. I think ke tlhaloganya jaanong putso ya gago abuti. Children's Act I know a mechanism that would address the way ubutisang kateng about. So it at that time when the child nasa bewa ko foster care, ha over 18, then court ikasi may as a foster child. Ubane purpose ya foster care, it's about providing care and protection. And then a court order ya foster care that it enables a child to atole the resource, the services that the department, government, including foster child grant. So, basically, Children's Act aina provision or in this bill, address the way it puts Thanks.
Okay, thank you very much. Ke a leboga, our stakeholders, our important guests, for having conducted yourselves in this, decent manner. Le botsitse relevant questions tse leng hore I hope everyone has benefited from the responses that the team has provided. Ka se sebaka ke tlo invite Honorable Member Thogoma Gagula a re lebohe ka he re fitlhile ko bofelong ba our public engagement. Over to you, Honorable Magagula.
Thank you, Chairperson. And honorable members, our support staff, and all our participants. Firstly, I would like to thank the host, Mayor Jeki, Councillor Jeki, panel in her absentia for allowing us to use the venue and also hosting us in the region of Mogale. And Chairperson, also I would also like to say you have conducted this meeting and in a manner that make us to all be disciplined. So your chairing of this meeting has made us and taking us so far not to be out of order. So we would like to thank you that also in future you invite us to your meetings. And without you, I think this house would be in chaos. Members of the legislature, members of the committee, Mayor Engelbrecht, I think we are the only 3 members who are present here. We thank you for your attendance in this meeting. And our support staff, I think we have organized this and who are present with us here. We would like to thank you also because you have also abandoned some of your duties and come here, and that there was an instruction from your union that at a certain time you must not be with us, but we have tried to be with us, and so your conduct makes us to say we're proud of you. Our interpreters, I think we thank you also for being here, that where we could not hear through your gadgets, we have heard what the person who was participating was saying. And we hope that that's why we had a disciplined audience. And to all our participants from all the regions present here, I think, Chairperson, your selection of the participant was marvelous, and you selected the participant who understand the topic which you were involved in, and hence the relevant questions and also the relevant responses. We'll also like to thank the National Department for being with us here and all the directors in all the, from all the regions. And I think Sibongile, your presentation, seeing a because it was direct and to the point. And to hope that in future you'll amend where the participant will request to participate. And also you have made our lives easy in terms of amending this act because I think we had problems which has caused a backlog to date in terms of foster care. But thank you for taking care of the questions and the inputs from our communities in the previous meetings. And you came up with this such marvelous amendments. And I think with these few words, I would like to say, as we're going back homes, can we drive safely and arrive alive? And thank you, Chairperson. But the city, after this meeting, you will also be provided with lunch. Ningaishi city siabonga ni hambeni kahle. Thank you.
Okay. Thank you very much, Honorable Magagula, for the vote of thanks. Re fihlile mo bofelong ba our engagement. And after we have conducted all the sessions, the portfolio committee will take in all the comments and it will make its own recommendations, which will be tabled in the Gauteng Provincial Legislature for adoption. Once those are adopted, the necessary process will kick in. We will forward that to the NCOP, and the NCOP and the National Assembly will engage in terms of their processes of processing these amendments. And once the two houses agree, then they will take the bill, the amendment to the President, who will sign it into an act of law. And once it's an act of law, it will be public knowledge. All of you will get to know the final results on the Amendment Act. It will be more the radio, more the newspaper, and I'm sure Lerona as Portfolio Committee, we will call you again for a feedback session to tell you what actually is the act of law in terms of the children's bill. So thank you very much, Raleboha. Like Mema Gagula Ablezi, there's lunch in the foyer, but I've been told they are still dishing out into the packages. So if we can just be patient, 5-10 minutes, and then they will usher you out. Then you'll go and receive your lunch packages. It's a mailing code, so thank you very much.